Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome for another episode of All Things Policy. Today, we are joined by two very special guests, Akshetha and Pranjal from SAMA, the online dispute resolution platform. Now, to play this out in a reverse Bollywood format, let me tell you what is ODR. Reimagining dispute resolution from justice administered in a courtroom to a service that can be availed of anywhere. It shifts the focus from adversarial court procedures to collaborative, mediated solutions. ODR integrates technology with trusted mechanisms of dispute resolution, namely negotiation, mediation, conciliation, and arbitration. And now to talk about SAMA, as my friend tells me, SAMA is an online dispute resolution institution. Well, that is a mouthful. You can think of it as a company where a bunch of lawyers and engineers are solving India's justice problem. SAMA is reimagining how we resolve dispute and use technology to make it faster, cheaper, and better. Their motto is Suljhao Magar Pyar Se. And they wholeheartedly believe in the power of collaboration as a tool for effective dispute resolution. Now, shifting the ball in your court, Pranjal and Akshetha, I want to understand, what is your conception of justice? What are the misgivings from the existing systems? And where do you think ODR comes and changes its course? The canvas is yours to paint.
Thank you. Thank you, Ritul. Thank you, Shrikrishna. Thank you for hosting us. Let's dive into the questions. Before talking about our conception of justice, let's talk about the misgivings, right, of the present justice system. So we are aware, but let's just try to understand the impact of the problem. Resolving disputes in India is a massive, massive pain point. It takes a lot of time. An average case, 3 to 4 years. It will take us more than 464 years to clear the backlog of 5 crore cases we have. We have all the 5 crore cases, but there are some 40 to 45 crore cases which are not getting filed in the Indian courts because people think it's not worth their time and energy. And that's the unmet market. So that is the size of the problem. It takes a lot of money. Financially, it's not feasible at all. Every hearing costs around 1,000 to 1,500 rupees. People are spending 2 lakh rupees for a money dispute, which is worth 40,000 rupees. Almost 40,000 crores from our GDP spent on courts and litigation. That is the visible cost. There is also an opportunity cost. When all the time you are wasting in your courts and in the forums and the hearings, it can be used for your work. And that is also getting lost. And then the whole process itself. The process itself is intrinsically very adversarial. It requires people to fight. There's one winner, one loser. And the loser can keep appealing. And the whole tariq pe tariq perception accurately defines the state of our Indian justice system. So looking at these misgivings, our conception of justice is something which is not adversarial. It is something which is not based on fighting and resolving your conflicts. It is rather based on collaboration. Like, we strongly believe that conflicts are inevitable. Like you, Ritul and Shrikrishna, you guys are different people. You might have different perspectives and you might have disagreements. But that doesn't mean that there needs to be one winner or one loser. There can always be a via media. There can always be a settlement. There can always be a common understanding. And that's how we always, like in India, collaboration and talking and resolving your disputes was a very common approach before the Britishers came in. They say that panchayats were there to handle property disputes. They said when we had family disputes, we used to go to the elders of the family to talk it out and settle. Going to courts, being adversarial was considered a blot on one's reputation. But then the whole Anglo-Saxon system of courts came in and we became more adversarial. So our conception of justice is something which is rooted in collaboration. It's rooted in peace. Like we believe in access to justice, we believe in access to peace. And it's rooted in the leveraging the power of technology. So this is how we believe justice, how we look at justice at SAMA. And we believe ODR has the power to provide that. ODR combines the principles of collaboration and it combines the power of technology. So when you combine these two, magic can happen and we can really solve for the access to justice problem. Over to you, Akshetha.
Thanks, Pranjal. Yeah, I completely echo everything that you just spoke about. And that's the thing, right? Access to justice is a right that everyone has. but in theory. But is there access to justice for all right now? I would like to argue no. And that's okay. Society is layered, systems are very complex, it's evolved in different ways over time. And as Pranjal said, conflicts are inevitable. And it's really nothing to be afraid of. Some of the coolest inventions of the world has come because there are conflicts. But how you choose to resolve them is completely in your hands. And that's where we do completely believe that collaboration plays a big role, respect plays a big role. And if we just shift the lens and let go of the baggage of what we think dispute resolution should look like or has been for so long, and just open up to bringing in more collaboration, bringing in more technology, making it more efficient, I do believe we can reach more people and more conflicts efficiently and respectfully. So I think that would be a more wholesome form of justice as well.
All right. Thank you so much. There's a lot to unpack in whatever both of you have said. But I want to sort of take a step back and try to understand that justice, this also comes from the state's skeptic that I am. Justice inherently is seen as one of state's critical function, and this goes from time immemorial. So to say that state has a monopoly on justice, just like it has on violence, legislation and execution, etc. So considering states do not have the tendency to cede space for even things which they are not supposed to do, let's say airlines, scooter manufacturing in India, or hotels, or so many things, or oil production, or there's so much that the state does which it should not be doing. How are they conceding space for one of their biggest monopoly? What has your experience been? Is there a pushback, or is there support? How is the whole equation at play from both a behavioral, cultural point of view as well as a regulatory point of view? Now, to say a few things, I know that the mediation bill 2021 was out, or per se, most recently the Supreme Court declared that Section 12A of the Commercial Codes Act, which has in fact mandated institutional mediation. So I know there are, and the Niti Aayog coveted ODR report. So there is some movement from the state. So, but I just want to understand this whole thing in the larger scheme of things.
Okay, so I'll take a shot. Pranjal, you can add as and when. To be honest, it is a large problem, which even the state wants to solve. And it is such a large community problem that really requires a large community solution. Things have been going a certain way for so long, and take something as simple as just the services that we all use now. You can get a loan in just one click. You can get your groceries in one click. And if we're not able to match up the dispute resolution being that efficient, it's just only going to increase the backlog. It's only going to make it even more inefficient. So I think it is a common goal for everyone for this problem to be solved. And yeah, we do have to operate within more or less a large framework, but ODR right now is not extremely highly regulated. We've just touched the tip of the iceberg, right? So it is a beautiful space right now to be in because you're not very, very insanely regulated right now. So there's a lot of scope for innovation. There's a lot of scope for exploration. So I just hope that it stays that way, while we all figure out what is the coolest and most efficient way to solve disputes.
Right. And I think there's not a clear answer to this, right? Because we have done close to 10 government projects now. We have worked with state legal service authorities of Rajasthan, Gujarat, Delhi, Maharashtra. And we are also working with the police of Madhya Pradesh, who are the primary entry points of conflicts right now. So I think our experience has been a mixed bag. So one is we do understand that there is a primary objective, which they are also realizing that it is, as Akshay said, it's a societal problem and it needs a societal solution. So the openness to public-private partnerships is there. We are seeing in the member secretaries, the legal service authority secretaries, that they are willing to partner with a private entity, which reduces their burden. The police in Madhya Pradesh is willing to partner with a private entity to reduce the burden of cases on them. So that openness is there, but at the same time, we get pushback sometimes, from some states. We have our experience in Kerala, right? In our experience in Kerala, there was a pushback from the lawyers there, from the bar association there, because they felt that this is something, but it was not because they had a problem with the private entity. There was a lot of misunderstandings which got developed. They felt that the full justice is getting outsourced to a private entity. But Our angle is not that. Our angle is that you already have like a Lok Adalat process in place. We will help you in digitizing that Lok Adalat. So we'll be sort of the technical partners to the Lok Adalat. But there was a communication gap there and it got aggravated, and then the Lok Adalat didn't happen. They banned it. They banned the online Lok Adalat that time. So there was pushback there. But the lesson we took from there was not that the lawyers and judges are not supportive. We feel like 95% of them, if they see it's a good idea and if they think it will help, they want to help. There are always those 4-5% people who want to create noise, but we are not trying to focus on them, and we are focusing on the 90-95% people and trying to figure out a way. And other thing is, whatever said and done, courts are still there. There are non-compoundable criminal cases like rapes, like murders, which have to be dealt in court. What we are saying is that there is a large chunk of cases, civil cases, compoundable cases, which can be dealt without going to court, or going to court should be your last resort. The behavior change we are trying to bring in public is that if Akshetha and I have a dispute, our first response should be, okay, can we collaborate? Can we negotiate? Can we reach a settlement? Can we use an arbitrator? If all that doesn't work out, then going to court should be the priority. So the courts get time to focus on the real public policy heavy matters as compared, and we can deal with the matters which are actually capable of settlements. So the whole principle of ADA, that it is rooted in consent and voluntariness, that the two people are willing to solve it on their own. So that gives us the space to operate. So those two people can use a private player to settle their case. They can use a government annex mediation center to settle their case, but it is the choice of those two individuals. So that's how we are sort of trying to strike a via media. It is a tough sector. It is a regulatory sector, but we try to keep doing work with the government and the police as well to ensure that they also trust this, and they also don't look at us as adversaries. They should think of us as someone who wants to support them and who wants to reduce their burden ultimately.
I mean, this takes me back to Shankar Iyer or Shankaracharya had the book, The Gated Republic. And that is about how these RWAs, or how these elite colonies, they've lost faith in the state's ability to deliver goods and services. And be it water, be it electricity, the fact that all of us have a inverter in our houses per se, or the water tanker, or their own STPs for that matter. So because they've lost faith in the ability of state to deliver services, they've made or built either their own, or private players have come in to sort of aid that. Is this another facet of it, that we've lost in the ability of state to deliver justice? So the private sector is bound to grow? I mean, this is something which I'd never thought of, but like, any thoughts?
At least I think my personally, it is similar to that. I think the courts are tremendously overburdened. Like there is one judge for every 50 lakh population, whereas there should be one judge for every 10 lakh population. The infrastructure, their salaries, it's not the greatest. So it's not blaming them, but it is like they need help, they need support, and it has to come from outside. And I'm saying it is right now, it's the legal tech companies which are solving for it, but it can also come from outside the legal tech sector. Like we have a lot of people say that these loan disputes or credit card disputes, the banks might figure out a solution on their own, or these fintechs might figure out a solution on their own to resolve conflicts, or the way how Swiggy resolves your customer complaints. It doesn't go to a consumer forum. So solutions will come from outside, and that's great. Till the time the ultimate intention is that we need to make it very easy for a general public, for a normal individual to resolve his or her conflicts. That's it. So if we can help that by partnering with the judiciary, by providing an out-of-court settlement option, by providing an online dispute resolution platform, all that is absolutely fine. So yeah, I think I do agree to that.
All right, I think Shri has a question.
Yeah, so I had a couple of things to ask you. So firstly, while we understand that the system is overburdened, right? We have too many cases, too little number of judges, too less of court infrastructure to handle the cases. It is also a fact that the state is the biggest litigator in the country, especially at the higher judiciary and upwards. So the question is, how proactive has the state been in adopting mediation for disputes it itself is a party to? And do you think that is growing? And the second question I have for both of you is, so we have discussed few ways in which, mediation has been institutionalized. First is through statutory mandates, where the legislation clearly says that you have to go to a mediation before you actually file a suit. And a couple of days back, the Supreme Court has also affirmed this in the context of Commercial Courts Act. And secondly, there are lok adalats, which can be made better through digitization, as you said. And thirdly, you have other outreach initiatives by, say, the police who are adopting mediation, right? So, what are the other kind of solutions which can come up, which you have thought of, or which other countries are doing, which sort of institutionalize mediation in India?
Right. So, Aksha, feel free to add. With respect to the first point, Shrikrishna, right? So, the government there's no doubt, they are the biggest litigant. 50 to 55% of the cases are by the government or against the government in India. One thing I feel is like, one is the resource issues, that number of judges are less, the infrastructure is weak, all those things. But the other, like, I strongly believe that the other problem is also the approach. Like, the Indian courts being on an adversarial system, I believe is a big problem. Not all family disputes, not all civil disputes, they need an adversarial approach. They can be dealt through a settlement, they can be dealt in a collaborative manner. So even if you fix the resources, there is still very important that there needs to be a transition from adversarial approach to collaborative approach. Like we look at the US, like less than 1% of the cases go to court or go to trial. 98 to 99% of the cases are settled out of court, or they get settled during litigation. So that is there. With respect to government, we have seen a transition, Shrikrishna. Honestly, like in 2017, 16, when we used to speak to like different government departments and we used to speak to the secretaries, they were very apprehensive of mediation. And they had a very legitimate reason for that, which was that if they settle a case with the opposite party, it might look like there is some bribe involved or they're compromising. It might not look good optics wise. It primarily because of that, the government department used to be away from these collaborative settlement processes and they used to rely on more like a third neutral party, like a judge deciding who's right and who's wrong. But that is shifting though. Like we are seeing now the government, as you also gave an example of so many legislation, but from 2017 onwards, like government released a notification saying that these are the 10 ODR, ADR platforms of India. And they ask government departments that if you have disputes, use these ODR platforms to reduce the burden. That was a push from the government. Then we see the whole Niti Aayog ODR policy coming out. Even these different types of laws, as you spoke about, right? Mediation becoming mandatory. All this is, there is a mindset shift where government is also becoming pro-ADR, pro-ODR. Right now, we haven't seen, like personally for SAMA, we haven't seen government departments as such referring cases. Like we're not getting cases from a railway department or an electricity department. That is not happening. But we are one entity which we are seeing there is a lot of scope is the legal service authorities. They, under the NALSA Lokdas Regulation 2009, it allows them to partner with private parties for administrative assistance. And that's what they're doing with us for online lok adalats. The Section 12A mandatory mediation is great, but I feel like the only problem with there is that the full scope of mediation is given to NALSA, Legal Service Authorities, and NALSA and Legal Service Authorities are very good in legal aid, but they're not very good at handling high-stake commercial complex disputes. There are a lot of private mediation players out there which can help in this. And we remember that Justice Madan Lokar, who the former Supreme Court Mediation Committee head, he called a meeting in 2020 of all of us. And he said that NALSA cannot take care of Section 12A again. We need to partner with private players. We thought that was a good starting point, but nothing happened post that, unfortunately. But yeah, in Section 12A, to really realize its full potential, I feel like NALSA needs to actively partner with private mediation players and give them the burden of solving commercial disputes. Yeah, so I think with respect to what more can be done, like right now, like personally, I feel like police, there is a lot of scope. Right now, we are working with 52 districts in Madhya Pradesh, and we genuinely feel that before filing an FIR, a lot of cases can be settled through online mediation. So that model can be replicated by other states. We also feel legal service authorities can take use of ODR platforms for specific use cases, like for insurance cases, they can take help of an ODR platform. For traffic challan cases, they can take help of an ODR platform. We see a lot of scope in MSMEs, like MSME payment disputes. There, they can also take help of an online arbitration, online conciliation platform to settle the disputes. There's a lot of government apps like Nyay Bandhu or TeleLaw, they have a lot of common service centers across the country. So for giving legal guidance to people. So guidance is level 1. After that, if the person wants to resolve his conflict with the other person, they can refer it to an online mediator and he can try settling the case between both the parties. So we do see these are certain more entry points where government is pushing, but yeah, at the same time, we don't like the mediation law, etc. We don't want them to come up with a law which is very, very, very heavy on how the process should be done. It should lay down the general guidelines, but not exactly, because the whole beauty of ODR and ADR is flexibility. What parties want, how they want it, that's how the process can be. So it should not become because then again, it will become like a court process again. So this is something which we want to be cautious of. But otherwise, right, definitely we see a shift in government pushing for ADR, ODR from like 2016 till now.
Yeah, I think just to add a few things there. One, also, Shrikrishna it is in line with the whole digital India or, making India adopt more digital services. So ODR, I think, does sort of fit the bill as well. So that's definitely one thing. And in terms of the last couple of years, one of the things was, as much as we see mediation being extremely successful in the West or in another country, it took a while, I think, for people to go, okay, we need to understand what mediation is in the Indian subcontext. We are a very different country, incredibly diverse. That is just in terms of culturally all languages, right? So over time, when that sort of set in and we were looking at mediation from the Indian subcontext, I think that became a game changer. And people were able to really visualize and understand what mediation is like for India. And yeah, as Pranjal said, I think I'm personally very curious about the MSME sector. Also curious about just the differently abled people. Their access right from just logistically has been very difficult with our current offline court systems. So what would it look like maybe to inject and leverage the power of technology there? That's something that I think we're really curious about. But yeah, overall, there is no doubt that there has been a shift.
All right. Thank you so much. This was quite enlightening. Now, let's take a break before we come back and discuss some more issues. All right. Welcome back. Now, Pranjal and Akshetha, I remember I was talking to Ambassador Lata Reddy and I asked her, what does it mean to be a diplomat? Like, what do you do? And she said that she was asked the same question by a kid. And she said, and I was like, what do I tell her? And her answer was, in the most simplicity, we make friends for India outside. So I want to throw a similar question to you. Now, if you had to explain it to a kid, what does SAMA do? What do you guys do? How would you sort of place it? You can take it from a kid to a policy nerd, like let that be the range of explanation. But yeah, that's the question.
It's funny that you asked this right now, because we recently actually did a form of a video with children, and asking them what their approach to, of course, in like more simple terms, was just understanding how they understand conflict or how they understand conflict resolution. And it's so beautiful, that there is a lot of innocence. And I think a lot of the adversarial mindset is something that you learn. You're not particularly born adversarial. And it was very simple. Like, you pose a question to them, give them like a conflict scenario, and their first reaction was, oh, I would just ask them why they did that, which is basically the crux of collaborative dispute resolution. The idea is not to really hurt the other side or to really have like a win-lose situation, but really naturally move towards conflict resolution. So I think, and it was so cute and it was so sweet to see that innocence and also realize that, oh my God, we actually grow up and being adversarial is something that we learn, and it's not something that comes very naturally to us. At least that's my opinion. So yeah, I think when that comes out, we'll send that to you as well. But it is not something that you're particularly born with. Pranjal, is there something you want to add here?
No, I was just trying to think, how would I explain to my nephew what we do? So I think at a very basic level, like SAMA helps you resolve your fights, and like resolving fights becomes very easy on SAMA. And that is something like our crux. Like, we really, like, every time we are taking a decision, we want to figure out that, is it going to help people in resolving conflicts? Is it going to make it easier for them? Whether it's time wise, whether it's money wise, whether it's the whole experience wise. But that is the point we keep coming back to. SAMA wants to make it very easy for people to resolve their conflicts. Does that help, Ritul?
It absolutely does. But yeah, now on the more advanced side, like how does the mediation process look like? How is it initiated? How much is the time taken, the cost, the stakeholders, the success rate? Can you take us through that process?
Sure. So let me give a brief on that, right? So right now, for example, we have 3 entry points for conflicts. We are getting disputes from companies disputes with their customers. So we have around 42 companies like ICICI Bank, Kotak Bank, OLX, Snapdeal, Udaan, them giving us disputes. Then we get disputes from the police. That's the second entry point. And the third is we get disputes from the legal service authorities. Now, all these 3 entry points have different processes they want. So we have a bunch of processes. We provide all ADR processes. So mediation, conciliation, arbitration, lok adalats, all these are provided online by us. So state legal service authorities, they're using us for online lok adalats. So Maharashtra, for example, when they did their national lok adalat, they partnered with us and we settled the cases for them. It's the full lok adalat process according to the law. Like it is according to the lok adalat regulations. We're not changing anything in that. We are just bringing it online and we are using our mediators to settle the cases. And then we give the cases back to them and they put their seal onto it and it becomes a lok adalat decree. So with legal service authorities, it's like an online lok adalat process, which goes for 1 month. And then there's 1 day of national lok adalat where all the lok adalat decrees are signed and they are shared with the parties. That's with them. With the police, we are doing online mediation. So if you go to a police thana in Indore, the police thana will ask you that, we have partnered with SAMA. Before filing an FIR, do you want to settle your case? These are the benefits of settling your case. It will take you less than 7 days. It's free of cost. It is also confidential. So it's ghar ki baat, your reputation, your respect will be protected. So then if you're convinced, then police with your consent, he will refer the case to us. And then we will appoint like a family mediator who will try to do the mediation. And in 7 days, he will try to reach a settlement. So that is with the police. Online mediation, 7 days window. With the legal service authorities, online lok adalats, 1 month with the final Monday of lok adalat. Now coming to our enterprises, which is where our commercial model also lies. So the enterprises, they are putting SAMA clauses in their contracts. So if you go to ICICI Bank terms and conditions, or if you open the OLX website, they have a SAMA conciliation arbitration clause, or they have a SAMA dispute resolution policy put on their website. So customers, by virtue of buying their products, they're agreeing explicitly to this online arbitration clause. They're agreeing to this online conciliation process. So with the banks, enterprises, we are generally seeing this format. They first file the case, they try to settle it through the process of conciliation. And it's called conciliation, not mediation. Although the process is exactly the same. Right now, as of today, we do not have a mediation law in India. A mediation bill is there, but it's still not become a law. So we use the Conciliation Act. So any settlement which happens in a conciliation is binding like a court judgment. So that's why we use conciliation with enterprises. So first 21 days, our conciliator will speak to the customer, speak to the bank. We will have some idea of a settlement matrix from the bank. Like we have an idea of what kind of settlements they are okay with. Accordingly, the conciliator will speak to the customer. First, there's just a lot of listening and acknowledging this problem. COVID has hit a lot of people very badly, so their financial businesses have been hit. So they try to understand that. The conciliator will also try to show the customer the bank's perspective. Ultimately, the bank is a custodian of public money and they have to figure out a way to recover that amount. So the conciliator will try to understand the cash flow situation of the customer. And this I'm giving example of a money dispute. And depending on the cash flow situation, he will try to come up with a proposal. He will run that proposal by the bank. And if the bank approves, we have certain templates of conciliation awards. They'll use that. It will be e-signing will happen, e-stamping will happen. And that's done. But in case in 21 days, if they are not able to settle the dispute, they will escalate it to arbitration. And arbitration is like a litigation process, just as it's like a private litigation. It's happening fully online. We have an arbitrator. Most of the arbitrators are like retired district judges or very senior lawyers who will decide, like they will hear from the bank, they will hear from the customer, and then they will pass a judgment. Which is called an arbitration award. That award has to be a reasoned award. Either it can be in favor of the customer or it can be in favor of the bank. And that's how the process gets closed. Right now, we are doing fast track arbitrations, which is document driven arbitration. So that takes around 45 to 60 days. So for enterprises, 21 days of conciliation plus 60 days tops for arbitration. So in 3 months, they are closing their dispute maximum through online conciliation and arbitration. Did I miss anything, Akshetha?
The cost, I would say.
Yeah, the cost. So for the police, for example, right now, so our government projects, our approach is like we do subsidized, either subsidized or pro bono. We do it pro, like all our online local, like the first 5 local adults we did were fully pro bono because we were trying to prove that it works. And after it started working, for example, in Maharashtra, first 2 online local adults were free. And after it started working, we started charging them per district. Like per district, there is a fee. And then per settlement, there is a fee. So that's how we sort of combine, but it's still highly subsidized. We don't honestly break even when we do government projects, but that is okay. We feel like because ODR gets so much validation, especially if a Maharashtra Legal Service Authority or a state government is using it. So the belief, even the companies, enterprises who are participating in Lokadal, their belief in ODR also goes up. So we believe that's worth it. That's why our costing like is that for Lokadals. For police right now, we are not charging again because for the Madhya Pradesh police, we are doing like a 6-month pro bono project. And though our hope is that they will see the settlement rate, they will see the reduced burden on their police officers, and they would like to continue the project. And when they would like to continue that, we will figure out a pricing either per case or per settlement accordingly with the police. So as I said, with government, it's either pro bono or subsidized. With the enterprises, however, there is a flat fee which we charge them for conciliation and arbitration. And that flat fee is according to the claim amount. So for example, if the disputed amount is between 0 to 1 lakh, so our fee will be 1,000 rupees. If it is between 1 lakh to 2 lakh, our fee will be 1,500 rupees, and so on. It keeps going on till 20 lakhs for certain housing finance cases. It also might go up to 1 crore claim amount. So depending on slabs, we have flat fees, and that's how we charge the enterprises. Enterprise bears the full cost. We tell the customers this upfront that enterprise is paying for this online conciliation arbitration. If you feel that disturbs our neutrality, you can also share the fee with the enterprise. We have not seen anyone sharing the fee till now. So customers like the fact that it's fully taken care by the enterprise. So yeah, this is how our revenue model with the 3 entry points work.
Thank you. Thank you so much for that detailed breakdown. Fast and friendly dispute resolution is every litigant's dream, right? So we do hope like that is achieved as soon as possible. However, I'll play the role of a bit of a skeptic here. So let us assume that I'm an aggrieved person, right? There is already a huge disincentive for me to approach the existing system, right? To file a case or to file a complaint, because I know like it's an arduous process. It's going to cost a lot. It's going to take a lot of my time. And I may not have the energy, the mental energy to do it, so on and so forth. So what happens is my first interface then becomes mediation, which is sort of maybe in a situation where I'm signing up to a contract with the bank. These are shrink wrap contracts where, the terms and conditions are set. So this is forced down on me and I have no other option. I have to go for the mediation. And similarly, say I'm going to a police station to file a complaint, and the police might just be happy to pass the buck and send the case to mediation than register an actual complaint and take investigative action. So then there is also the angle of fairness, right? So ultimately, as a mediation service provider, you are servicing the police or say the company in our examples. So as an individual aggrieved person, what are your incentives to ensure that I get a fair deal? So my question to you is about all of this, right? If I have to sum it up, what are the safeguards which exist for me as an aggrieved person to opt for this mechanism?
So I think one of the biggest points that needs to go through is that we are an independent, neutral institution. And like you said, it's true. There is an awareness literacy angle to this whole thing, especially if you're upset, right? And I think that's where trust building online really comes into play. What that means for a service provider like us or an ODR institution like us is just that the technology we build has to be thoughtful technology. The communication, both in person, like a human element, or even if it's just text, it has to be done correctly with the aim of trust building and one that really instills confidence. So it becomes so careful that, we need to be so careful that we're making sure even our supply, which is basically if you are interacting with one of the mediators, truly embodies the spirit of collaborative dispute resolution, or for us truly believes in Sulha Wada Pyar Se. So it is not rare for us to meet someone who says, how can I trust you? Or what do we do? And one of the biggest things, whether it's been an enterprise, whether it's been with the police, is driving home the fact about our neutrality. We don't represent the bank or the police, or we don't represent you, right? We are a neutral, independent institution that's here to sort of bring the two stakeholders together and give you a safe space and in a more efficient way to solve that dispute. And when you also counter that with the pain points of what would be your other option otherwise, well, we've already discussed what it would be like to maybe take that to court. And like you said, you're already tired. The opportunity cost is very high. The financial cost is very high. So it is a combination of making sure that a lot of literacy is first passed on to the individual. You need to understand what the mediation is, what that sort of ecosystem is for you, and what role SAMA plays, what role we as ODR providers play. And I think that has worked. That's how people consent and then move on for the process.
Right.
Pranjal, does one add?
Right. With respect to your point, Shrikrishna, of safeguards, right? So let's take two examples. One for the police. So police is online mediation, and the pillar of mediation is consent. So for example, if you go to a police thana right now in Bhopal and say that I have a case, I have a family dispute with my brother or whatever, the police will first tell you that, okay, we have a partnership with this. They have been trained to sensitize the litigant on the benefits of mediation. So he tells you the benefits of mediation. And then only when your consent comes, he will give you a receipt which will have your consent. Then at the second level, while filing the case on SAMA, that Shrikrishna's case, he has consented. The police is also giving a declaration saying that the case is suitable for mediation. There is no risk of safety, and Shrikrishna has clearly consented. So that's the second level of consent. First is by you when you're coming to the police thana and you are agreeing on that bill book when you're getting a receipt of the case. Second, when the police is filing the case on a platform. And the third safeguard is even when the case is filed, our case manager will call you and say that your case has been referred by the Bhopal Police Thana to us. And are you okay with online mediation? Do you want to give it a shot? Do you want to try settling? And even if you say no, that I actually didn't want to, the police just passed the buck. They were not taking my case seriously. And that report will immediately go back to the police saying that's a closed, no settlement. The party doesn't want to participate in mediation, and the process for filing the FIR will be resumed. So we are putting those safeguards to ensure that consent is voluntary and genuine. That is one. With enterprise, there is a whole thing of consumer due process protocols, which SAMA adopts, which is basically like even abroad, we have taken this from that they have a concept of mandatory arbitration or conciliation. But when you're doing that, as an ADR agency, you have to ensure that certain safeguards are put in place. What it means is, for example, disclosure, that you have to tell the customer that the fees is being paid by the enterprise. Do they have a problem with that? The customer really needs to understand ADR, what it means. Like a lot of them don't understand arbitration mediation. Very simple Hindi language, how you understand how you make them understand arbitration mediation is very important. They also need to know that although there is a conciliation arbitration clause in their terms and conditions, it doesn't bar them from going to the consumer forum. They can still go to the consumer forum and file a case. So all that information is given to the consumer. And then the benefits are also told that, you don't have to pay. It's fully online. There is a proper expert conciliator who you can tell your problem and you can try to reach a settlement. And honestly, like Shrikrishna, what we are seeing right now is we, like our arbitrators, conciliators, like the assumption, like the most possible apprehension can be, that, the enterprise is paying SAMA or enterprise is paying. Arbitrators might give awards in the favor of the bank, or settlements might be in favor of the bank. But we are actually seeing opposite. A lot of we tell our conciliators, we tell our arbitrators that you're not representing the bank, you're not representing the customer. Your point is to be neutral and help them reach a fair settlement. But sometimes I feel like most of them, in fact, sometimes they become consumer facing. They try to get the best possible settlement. Or even if the consumer has said something, that I need 6 months of time or 7 months of time. Like in our arbitration awards, we are seeing 7 to 8 months, 10 months of time is being given to customers, even to customers who are not actively asking for it or ex parte or they're not able to reach. So right now, like our sense is that the awards and the settlements are in the favor of consumer. It's also more consumer facing so that they also feel that it's fair. And if they still want to appeal or they want to challenge the settlement, there are in-house appellate mechanisms which SAMA has. So if you're not happy with the award of an arbitrator, you can appeal, and that award will go to 3 arbitrators of your choice. And we have around 3,000 arbitrators from 443 cities. So they can choose nitpick any 3 arbitrators, and those 3 arbitrators will provide a review judgment. And that will happen in 30 days, as compared to if you're not happy with an award and if you want to challenge an award in the court, that can take years, a year or two. So we try to put these safeguards to minimize biasness and ensure that neutrality is there. It is a continuous challenge, but this is how we are tackling it.
Thanks, actually. I mean, you answered the challenge part without we even asking it. But so this brings us to my final question, which is that we understand that these cases are mediated and resolved, but is there a way that you sort of monitor and evaluate the outcomes of this process? Like, how do you sort of close the loop? Because as I understand, there is no legal enforcement. So, I mean, it is ultimately left to the people. So is there a way that you track it? Is there an impact assessment, or so that like how many cases are actually going to the courts, or how many cases are resolved and then need no further intervention? So is there a way that you do it? And also, if you have any closing remarks, both Pranjal and Akshita, feel free.
Right. So with respect to enforcement and compliance, so we do not have a full-fledged system in place, but we really want to enter that space, and we have taken 2 initiatives. One is like, we have a team called a SAMA fulfillment team, which is when the settlements happen, they follow up with the enterprises that has the customer complied with the settlement terms. And we did it with few of our enterprise, and we saw that there was a 40 to 45% compliance. So for example, if the settlement amount was of 2.5 crore, the actual compliance was of 1 to 1.1, like 1 crore 10 lakh rupees. So that we are trying to see, and we give a fulfillment score to the conciliator. Like, we are trying to tell mediators that it is not enough to just come up with a settlement. Your settlement agreements should be so strong that people comply with it. Then it should stand the test of times. So that is one part. The other is respect to arbitration awards. Right now we have 8 to 9 active arbitration enterprise users. And we have told them that anytime they go for enforcement of the arbitration award, just keep us updated on the progress. They ask us for the enforcement file. So we give them the full file, which they have to put in the court. So that's the way they keep us updated. Now, one thing which you're not sure, that's, are all enterprises telling us when they're going for enforcement? That may not be clear. But we have given this request to all our enterprise clients that whenever you file our SAMA award for execution, do keep us updated on the progress. So that's how we try to stay updated with what is happening post the award. Even in Madhya Pradesh, it's a 6-month project. So we have constituted a separate fulfillment team for MP. So whatever settlements happen, the team will follow up. Like 15 days later, there'll be a call going from the fulfillment team to the litigants that, hey, your dispute came, it was settled. Is everything okay now? Is there a problem, etc.? And the compliance will be checked, and a report will be sent to the police thana and to the mediator. So we really believe that we should resolving conflicts is not just about passing a settlement agreement or passing an award. It is about resolution end to end. So from filing of the problem to sending the notices to the communication to the award to the compliance, everything should be handled and facilitated by us. So yeah, that's how we are that's how we are looking at compliance and enforcement right now. Akshay, you want to add?
Yeah, I mean, since you were asked for closing remarks, there were just a few things that I'd leave you with would be, one is just, to the people listening, we keep saying this, that the internet is a new medium with new opportunities. And if we just look at it from that lens, I think we leave ourselves open to so much more exploration, more acceptance. Just, there is a lot of unknown, and there's so much potential for new things to come up, especially in the space of dispute resolution. The second thing would be, now, let's say with UPI and your GPay, and would any of us now be okay with having to go and stand in line at a bank, your branch, and then get money physically? Not anymore. I think people are just like, hey, my time is precious and I will just GPay it to you. And that's the thing, there is scope for the legal space and the dispute resolution space to also have that level of efficiency. So maybe we have to stop being okay with the fact that, oh, if I have a case, I'm going to spend 4 years, I'm going to spend 5 years. I think we should now say, no, I do think my time is valuable and my money can be spent correctly to solve this dispute. And what if I tell you that the future of dispute resolution might actually be a combined effort of like therapists and lawyers, counselors and lawyers, or, maybe that's a key to some set of use cases where probably right now there are some use cases that haven't even been tapped into, right? And there is so much scope for that to be done correctly and collaboratively. So the next time you do have a legal dispute, you do have a conflict, I would urge you to just remember, सुलझाओ मगर प्यार से.
All right. Thank you so much. I think this is a heartening note to end. And considering this is a conversation on justice in India, this is actually a very positive note. So thank you so much. This was extremely insightful. I'm sure both me and Shri and our listeners will have a lot to take away from this. And at the risk, I want to say that thanks for coming on our OPR for your talk on ODR. OPR is online podcast recording. So thank you guys. It was great having you.
Thank you. Thank you.
Thank you.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.